Hello everyone, my name is Helen Ekanem, a law graduate from Niger Delta University and a virtual intern at HARLEM solicitors. Today I'll be talking on the topic, the policies and practice of adoption in Nigeria. What is adoption? Adoption can be defined as a process by which a person legally assumes the role of a parent over a child that is not biologically theirs. Adoption also is a legal procedure in conformance with state statutory provisions in which the obligation and rights of a child towards his biological parent is terminated and a new right is created between the child and the adopting parents. Having said that, there are various reasons as to why adoption is usually considered. It could be as a result of childlessness, it could be to help teenage girls with unwanted pregnancy, it could be to sustain the line of the descent, it could be as a result of the loss of child. The list is unending. However, what is important to note is that adoption is very important to the society because it affects the rights of persons and needs to be regulated. In 1991 and 2002 respectively, Nigeria signed into law two international instruments, the UN Convention on Child's Rights and the UN Convention on Rights of a Child and the Organization of African Union Charter on the Rights and Welfare of a Child. That is not to say that before this time there was no law. The first legislation on adoption to have been enacted in Nigeria was in 1965, known as the Eastern Adoption Law. Now, moving forward to after the enactment, the signing in and ratification of this international instrument, Nigeria enacted the Child's Rights Act, being the sole legislation that focuses on the welfare of the child. Part 12 of that act deals with adoption processes in Nigeria. Now, having said that, it's important we look at the eligibility of who can be adopted and who can adopt a child in Nigeria. According to Section 129 of the Child's Rights Act 2003, a person that is not less than the age of 25 can adopt a child. I would want us to regard this person as an applicant. Now, the applicant must not be less than the age of 25, and the applicant must be older than the child he or she is seeking to adopt with 21 years. The law also, the Child's Rights Act also states that where this applicant is unmarried, the applicant must not be less than 35 years, and the applicant must adopt a child of same sex. What that means is that as a lady seeking to adopt a child and you are unmarried, you must not be less than 35 years of age, and the child you are seeking to be adopted must be of same gender as you are. Same applies to the men. Having clarified the eligibility of who can adopt a child, we move forward to who can be adopted. In all the relevant laws that govern adoption in Nigeria, they provide that only a juvenile can be adopted. Whoever is a juvenile differs on the laws. According to the Child's Rights Act in Section 128, a juvenile is a person below the age of 18 years who has not been married. Now, in Lagos State, Anambra State, Ogun State, a juvenile is a person below the age of 17 years whose parents or relative cannot be reached after much inquiry. In Edo State and Delta State, a juvenile is a person below the age of 18 years. The Child's Rights Act went on to say that this child that can be considered for adoption, who is a juvenile below the age of 18, who has not been married, must be someone that has been neglected, rejected, abandoned, persistently ill-treated. Such a person can be adopted. The act also states that where the parents of such a child is available, consent must be gotten from the parents before adoption can be considered legal. Having said that, we'll move to the procedures of adoption in Nigeria. According to the Child's Rights Act, the adoption application order must be signed in a prescribed form known as Form 3. This form will be accompanied by different relevant documents. For instance, the birth certificate, marriage certificate where the couple is married, financial statement of the couple. Need I remind you, when I mentioned earlier on the eligibility of persons that can adopt a child, the Act provides that such a person to adopt a child must be of unquestionable integrity and must be financially capable to meet adequately the welfare of the child. Right on back to where I was on the procedures to consider for adoption. Having filled the application order in the Form 3 with relevant documents, these documents will be taken to the ministry in charge of the welfare of children, being the Ministry of Women, Youth and Social Development. The ministry, being satisfied, takes these documents to the High Court. The High Court, on the other hand, goes through these documents, appoints a guard ad litem who would represent the child to be adopted in the adoption proceedings. The Act provides that 3 months before the adoption order is granted, the child is expected to have been in the care and custody of the couples seeking to adopt the child. After the adoption order has been granted, the Act provides that a development officer will be sent consecutively to the address of the adopting parents to look at the condition and the welfare of the child in his new home. I'd like to point out that the Act prohibits interstate adoption. However, there are instances which the minister, left to his own discretion, after considering the welfare and the condition of the child, can grant for a child to be transferred to wherever the adopting parents reside. Having said that, I want us to talk on the implications of adoption. After the grant of the order, there are certain things and certain implications that the adoption order carries along with it. First is that it transfers the rights, duties, and obligations from the biological parents of the adopted child to the adopting parents, meaning that the rights over the child from the rights of the natural parents over the child is terminated, and then the adopting child is now regarded by law as the natural parent of that child. It also transfers duties and obligations on the adopting parents to be able to meet and cater to the needs and welfare of the child, seeing the child as their original and natural child. Another implication of adoption in Nigeria is that after granting the application order, the child would have a right to the inheritance of the adopting parents. Also, the application order creates a deemed relationship of consanguinity between the adopting parents and the adopted child. By virtue of that relationship, every form of marriage is invalidated between the adopter and the adopted child, or between the children or child of the adopter and the adopted child. I would also point out in conclusion that adoption is irrevocable. However, where the court finds out that duress, undue influence, or fraud has been meted upon any of the parties during the adoption proceedings, the adoption order will be revoked. I hope you have enjoyed the lecture. For more information, please visit www.harlemsolicitors.com or visit Harlem Solicitors on our LinkedIn page. Do have a wonderful day. Thank you.